If you live in Texas, or if you have family members anywhere near the Texas-Mexico border, what I am about to share with you today is something you genuinely cannot afford to miss. Three major immigration-related bills moved through the Texas legislature during the 2025 legislative session, and they are now signed into law. These laws are not minor tweaks. They represent a fundamental shift in how immigration enforcement works in the state of Texas, and they will affect immigrants, legal residents, citizens with immigrant family members, local governments, and law enforcement agencies all across the state. So stay with me, because by the end of this video, you are going to understand exactly what passed, what it means for you, and what steps you can take right now to protect yourself and your family. Before we get into the details, I want to be upfront with you as I always am on this channel. I am going to give you the facts, I am going to give you context, and I am going to point you to where you can get help. But I am not going to pretend that everything is simple, because it is not. Immigration law is one of the most complex areas of the legal system, and the situation in Texas is changing fast. This content is for informational purposes only. It is not legal advice. For your specific situation, please always consult a qualified immigration attorney. With that said, let's get into it. To understand why these three bills matter so much, we need to step back for just a moment and look at the broader picture. For years, Texas has been at the epicenter of the national immigration debate. The state shares more than 200 miles of border with Mexico, the longest border of any state in the country. Beginning in 2021, Governor Greg Abbott launched what became known as Operation Lone Star, a state-level border security initiative that has now cost Texas taxpayers well over $11 billion. The state has built stretches of border barrier, deployed National Guard troops, and arrested thousands of people on state trespassing charges, all in an effort to supplement what state officials described as a failure of federal enforcement. That context matters, because the three bills we are discussing today did not emerge out of nowhere. They are the latest chapter in a years-long effort by Texas to insert itself more deeply into what has traditionally been a federal function, immigration enforcement. Now, let us talk about what actually passed during the 89th Texas legislative session in 2025. The two most significant bills that were sent to Governor Abbott's desk and signed into law were Senate Bill 8 and Senate Bill 36. And when you understand what each one does, you begin to see just how significantly the enforcement landscape in Texas has been reshaped. Let's start with Senate Bill 8, because this one directly affects every county in Texas that operates a jail. Senate Bill 8 requires most Texas sheriffs to enter into formal cooperation agreements with U.S. Immigration and Customs Enforcement, the agency most people know simply as ICE. These agreements are called 287G agreements, named after the section of the Immigration and Nationality Act that created them. Under a 287G agreement, ICE can authorize local officers to carry out certain immigration enforcement functions. Specifically, they can be deputized to serve administrative immigration warrants at local jails and to question people in custody about their immigration status. Senate Bill 8 was passed in the Texas Senate by a vote of 20-11 and then passed in the House by a vote of 89-52. It was signed into law and became effective on January 1, 2026. What does that mean practically for someone in Texas? It means that if a person is booked into a county jail, for any reason, even something as routine as a minor traffic-related offense, their immigration status may now be checked by local deputies who are acting under ICE authorization. If ICE issues an administrative warrant or detainer request on that person, local law enforcement is now obligated to cooperate with that request. Previously, cooperation with ICE varied significantly from county to county. Some sheriffs cooperated fully, others declined, citing resource constraints or civil liberties concerns. Senate Bill 8 removes that discretion for most county sheriffs. The Texas Attorney General has been given the authority to sue sheriffs who fail to comply with this mandate. This is a significant expansion of state-level immigration enforcement capacity, and it does not require a federal immigration officer to be present. It uses the local sheriff's office as the enforcement arm. The second major law, Senate Bill 36, operates at a different level. It restructures how the state itself is organized to handle immigration and border security. Senate Bill 36 creates a new Homeland Security Division within the Texas Department of Public Safety, which is the state agency that oversees the Texas Highway Patrol and other law enforcement functions. The bill became effective September 1, 2025, giving the department time to build infrastructure and hire staff before the full rollout. Before this bill, border security and emergency response efforts within the Department of Public Safety were spread across multiple units and divisions. Senate Bill 36 consolidates those functions into a single, dedicated Homeland Security Division, increasing coordination and accountability within the agency. It also increases funding for personnel deployment and surveillance technology along the border. Think of it this way. Where before the state's security apparatus was operating from several different desks, it is now operating from one unified command center. That has real implications for the scale and speed of state-level enforcement activity. Now, what about the third piece of this puzzle? Because I know many of you watching this came here for a complete picture. The third major element is the state budget itself. The Texas legislature, through Senate Bill 1, the state budget for the 2026 through 2027 biennium, allocated over $3.3 billion in continued border security funding. This enormous sum supports Operation Lone Star, continued border wall construction, surveillance infrastructure, and the sustained deployment of law enforcement and National Guard resources along the Texas-Mexico border. This budget was a direct follow-on to the state's existing commitment to border enforcement, and it signals that regardless of what happens at the federal level, Texas intends to maintain and expand its own enforcement posture. Texas Policy Research, which closely tracked the 89th legislative session, noted that this level of border security investment represents a multi-year trend the state launched back in 2021, and one that shows no sign of slowing down. I also want to mention a bill that generated significant debate during the session, but ultimately did not pass the Texas House, because understanding what failed is just as important as understanding what passed. That was Senate Joint Resolution 1, a proposed constitutional amendment that would have allowed Texas courts to deny bail to individuals who are undocumented and facing charges for certain serious felonies. Despite strong backing from Governor Abbott and Lieutenant Governor Dan Patrick, this measure failed in the Texas House. Its failure highlights that even in a heavily Republican-controlled legislature, some reforms face constitutional and legal hurdles that are difficult to clear, particularly when they involve detention policies that courts have historically treated as civil matters rather than criminal ones. The Texas Tribune and other credible outlets covering the legislative session also reported that lawmakers passed a property tax break for landowners who allow state or federal border barriers to be built on their land, and that a new E-Verify requirement for state contractors advanced as well, continuing the trend of using economic mechanisms to reinforce border and immigration policy. The Texas DREAM Act, which since 2001 has allowed eligible undocumented students who graduated from Texas high schools to access in-state tuition, survived the session intact, though it now faces separate legal challenges through the courts. So, with all of that on the table, let's talk about what this means for real people, for you, for your family members, for communities across Texas. If you or someone you know is undocumented or in a mixed immigration status household, the passage of Senate Bill 8 is perhaps the most immediately relevant development. The fact that county sheriffs in nearly every Texas county are now mandated to work with ICE means that any interaction with the local criminal justice system carries heightened immigration consequences. This does not mean that merely being undocumented is a crime under this law. It is not. But it does mean that if there is any encounter with law enforcement that leads to being held at a county jail, the immigration status question is now going to be asked, and ICE is going to be notified. What I strongly encourage anyone in this situation to do is this. Consult an immigration attorney now, before any emergency arises. Know your rights. Understand what an ICE administrative detainer is and what options exist. Do not wait until there is a crisis to seek legal guidance. If you are in lawful immigration status, on a visa, a green card, in the process of adjusting status, these laws do not directly target you, but they do reflect the broader enforcement environment in Texas, and it is always wise to have your documents in order, to know the details of your current status, and to have a qualified attorney you can contact if questions arise. USCIS and the Department of Homeland Security have official portals and helplines. I will point you to those resources in the video description. For employers across Texas, particularly those with large workforces in industries like agriculture, construction, hospitality, and food processing, the E-Verify mandate for state contractors is something your legal and HR teams need to be reviewing right now. E-Verify is the federal system run by USCIS that allows employers to check the work authorization status of their employees. If your company does business with the state of Texas, E-Verify compliance is moving from optional to required, and the consequences of non-compliance are real. For local governments, county commissioners, and county sheriffs across Texas, the mandate in Senate Bill 8 is going to require legal review and, in many cases, operational changes. The bill includes a grant program to help cover the costs of implementing the required 287G agreements, which is worth knowing because the funding assistance is there. But the timeline is firm, and the accountability mechanism, through the Attorney General's office, is in place. Now let's step back from the specifics and look at the bigger picture for a moment, because I think it is important to offer some context without taking a political side. The supporters of these bills argue that they are necessary because the federal government, for years, did not provide adequate enforcement at the southern border, and that Texas has a responsibility to its residents to fill that gap. They point to the real challenges that communities along the border face, the pressure on local resources, the criminal activity associated with smuggling networks, and the humanitarian concerns that come with large-scale irregular migration. These are legitimate concerns, and the people who raise them deserve to be heard. At the same time, critics of these bills, including civil rights organizations like the ACLU of Texas and legal scholars who have studied immigration federalism, raise serious concerns. They argue that immigration enforcement is, under the United States Constitution, a federal function, and that when states take it on, you risk inconsistent application of the law, the potential for racial profiling, and violations of due process rights for both undocumented people and legal residents. They point out that 287G agreements have a documented history of being misused in some jurisdictions, leading to profiling of people based on appearance or language rather than actual immigration status. These concerns are also legitimate. The Texas Tribune has covered them extensively, and they deserve honest acknowledgement. What I can tell you is this: the courts are going to play a major role in the future of these laws. Texas's 2023 Senate Bill 4, which attempted to create a state crime of illegal entry into Texas, faced immediate legal challenges and was ultimately blocked by the federal courts, with the Supreme Court affirming that immigration enforcement is a federal prerogative under the landmark Arizona v. United States ruling. The laws passed in 2025 are structured differently. They work within the 287G federal partnership framework rather than creating a new state crime, which may give them more legal durability. But legal challenges are ongoing and likely, and the outcome of those challenges could alter how these laws are implemented in practice. This is precisely why staying informed is so important, because the law that is on the books today may look different 6 months from now depending on court decisions, executive guidance from DHS, and changes at the federal level. As of the date of this recording, February 12, 2026, Senate Bill 8 is in effect as of January 1st of this year, and Senate Bill 36 has been in effect since September 1st, 2025. But immigration policy can and does change, and I always encourage you to verify the current status of any law through official sources: the Texas Legislature's official website, the Department of Homeland Security at DHS.gov, ICE at ICE.gov, and USCIS at USCIS.gov. Those are your most reliable primary sources. Here is what I want you to take away from today's video. Number 1, know your status and keep your documents up to date. Whether you are a citizen, a green card holder, a visa holder, or in any other immigration status, having current, organized documentation of your legal status is the single most protective thing you can do. Number 2, if you are undocumented or in a mixed status household in Texas, the enforcement environment has intensified. Please consult a licensed immigration attorney. Many nonprofit legal organizations across Texas offer low-cost or free consultations. Do not rely on social media or unverified sources for legal guidance. Number 3, if you are an employer or a local government official, get ahead of the compliance requirements now. Do not wait for an enforcement action to prompt a review. Number 4, stay informed. Laws are being challenged. Policies are being updated. Court rulings are happening. The situation is moving quickly, and the best thing you can do for yourself and your family is to stay educated and connected to reliable sources of information. I want to remind you, before we close, that this channel, Immigration News Today, exists precisely for moments like this one. We cover immigration news as it happens. We break down complex legislative and policy developments into plain language, and we try to give you the kind of honest, grounded information that helps you make good decisions. We are not here to alarm you. We are not here to push a political agenda. We are here to help you navigate a system that can be genuinely confusing, and to make sure you have the information you need to protect yourself and the people you love. So, if you found this video helpful, and I genuinely hope you did, please take a moment to give it a like, because it helps more people find this content when they need it. Share it with someone in your community who needs to know what is happening in Texas right now. And if you are not yet subscribed to Immigration News Today, hit that subscribe button and click the notification bell so you never miss an update. We have important content coming up covering the federal One Big Beautiful Bill Act, updates on USCIS processing times, changes to asylum procedures, and much more. You do not want to miss any of it. Check the description below this video for links to official resources, including the Texas Legislature's Bill Tracking System, DHS, ICE, and USCIS official guidance pages, and information on finding qualified immigration legal help in Texas. Remember, this video is for informational purposes only and does not constitute legal advice. Immigration policy can change. Please consult official sources and a qualified immigration attorney for guidance specific to your situation. Thank you so much for being part of this community. Stay informed, stay strong, and we will see you in the next video.